Hi, my name is Bob Bianchi. I'm hosting today at the Law and Crime Network, and welcome to our Sirius XM viewers. And I'm very honored to have an opportunity to have my great guest, Dan Schorr, with me, who actually works as a managing director at Kroll Investigations, which is an investigative firm. Very interesting background, because Dan also was an ADA in 2 district attorneys' offices in New York, working in the Special Victims Unit and doing homicide investigations. So I couldn't have a better guest. Dan, welcome to the show.
Thanks for having me. It's been great to talk with you, Bob.
Yeah, definitely. So listen, I love having a pro here, a guy who's a trial guy. We could talk about these nuance and tactics. We just listened to the rebuttal statement of the prosecutor in this case. And just for those of you who may not know, this is an individual who was accused, he's 18 years of age, of having shot 2 rounds into the bedroom of his ex-girlfriend, right in the vicinity of where her bed is, Dan, and ultimately one of those rounds struck her in the head, and the testimony that we have is she was pretty much immediately incapacitated or dead as a result. And Dan, this case is coming down to a couple of things. Prosecution says it was intentional and premeditated, and there's a whole history of weird, squirrely stuff this guy is doing, and the defense is saying, look, this is a young 18-year-old teenager who did a stupid thing, a reckless thing, but it was not his intention to kill. What do you think of the closing statement so far, and what do you think is most persuasive to you?
Well, I think both sides are doing the best they can with the evidence, but the facts are really on the side of the prosecution here, because it comes down to intent. And here you have the defendant actually, excuse me, he went up to the room outside the home of the victim and shot right through the window or right by the wall where she was sleeping. He had been in that room. He knew where her bed was. He had to have known that these bullets would be approximately where she was sleeping. And the defense is trying to argue, yes, he fired these shots, but he didn't know that she was sleeping there, or he didn't think it would hit her, or in some way he didn't intend to kill her, that he wanted to be this hero that was going to create a danger the way he had kind of in the past, and then he would be able to rescue her or be looked at with attention from her. It's hard to believe that when he's had this stalker behavior for a long time, and then he shoots 2 bullets right by where she's sleeping.
Hey, Dan, some great points. But, listen, I love going to the Law and Crime Network website and watching our really astute viewers who are blogging comments all the time, and we welcome them and try to answer them whenever we can. Of course, the Sirius XM people don't blog while you're driving. We don't want you to be one of these cases. But nevertheless, you can listen to some very insightful comments from the people. And, what I'm seeing so far in these blogs, people are kind of conflicted. A lot are saying murder, but some are saying the prosecution just hasn't got there. And remember, Dan, we know this is prosecutors. It only takes one juror, only 1 out of 12 people, to say, I'm just not convinced of the murder, and that would therefore be a not guilty. But I say the prosecution has an ace in the hole, Dan, and that is called felony murder. Many times juries will compromise on cases like this and say, well, we don't know if he necessarily intended it to happen, but in this case, Dan, and for our XM viewers who may not have been listening to all of the trial, there's a felony murder charge, which means if you can find what they call a predicate act, it's not every crime, not every felony, but if there's a certain felony, in this case, it's child abuse, child endangerment. And during the commission of that predicate offense of child endangerment, somebody dies, then you are guilty of felony murder, as if you committed the murder itself. And I think, Dan, and I'm curious about your background and experience in this, I think it's very capable. I've seen it happen in homicide cases I've tried, where they may say, I'm not comfortable with necessarily intended to kill her, but I'm comfortable with felony murder. What are your thoughts?
That's true. It's a very good point. And the other part of that is the jury doesn't know the sentencing, so they may see felony murder. They may not realize that that could be the same sentence as a intentional murder conviction, and they may think it's a compromised verdict, but it may lead to the defendant facing the same amount of time. But to me, the intent is still strong here, because what could his intent really be if he's shooting in close proximity to the home, shooting 2 bullets right where he knows she would be sleeping? It's hard to imagine another intent. If he wanted to just scare her, create a disturbance that she would seek him out for comfort for, he could have shot it near the home, a different part of the home, but it was right where she sleeps, and he knew where she slept. So why would he shoot there if not because he wanted to kill her?
Some great points. Hey, listen, guys who are blogging on the Law and Crime Network, keep those questions coming. And for our Sirius XM viewers, it's great, listeners rather, it's great to have you a part of the show. Right now, we're going to toss to a commercial break, and on the other end of that, we're going to come back with some great, more trial analysis by Dan and hopefully myself. Thank you. All right, Wowzy, we got some great cases, and we're going to go into the Grate case, and I'm interested in Dan's opinion about that. Sean Grate, serial killer, and listen to our Law and Crime viewers that are blogging on here, seen some amazing comments to our Sirius XM listeners. This is a case where an individual, I find this compelling. Look, I've done this for 30 years. I've tried a lot of cases, but every now and again, especially in the murder world, they're kind of routine after a while. I'm sorry to say you kind of get that way, but then there's one that comes across your path where you're like, yikes, man, this is really bad, really creepy, really weird, really bad guy. This is a prosecutor's dream. How do we know about this case, Dan? And for our XM listeners who may not have been necessarily listening to all of this case, this is a guy who was literally in the process of raping and kidnapping a young woman. It was a harrowing tale in an empty building. This woman with no doorknob on the other side of a door couldn't escape. And the guy fell asleep, and she took his cell phone and called 911. And for all of you, if you get a chance, go to the Law and Crime Network and listen to this 911 tape. Dan, I actually tried a case with a 911 call where somebody was being murdered, and it was captured literally on the 911 call. And yet, that is nothing compared to the bone-chilling call that this young woman placed to the police. And the police were trying to find where she was at. She was afraid to speak. She was afraid she was going to wake him up. The guy had things devised in the room so that if she moved, it would alert him to the fact. And then after this, it all unraveled for this person, and it's later determined that he killed at least 2 other women for which he's on trial. During the course of the trial, he pled guilty to a number of offenses, Dan, but he left what they call the capital murder offenses for the death penalty still on the table for the jury. They went out yesterday. They came back toot sweet, guilty on all the capital murder offenses. What are your thoughts about a case like this?
Well, first of all, that 911 call is just haunting, because if you could put yourself in the shoes of that victim, she's been sexually assaulted. She's in a house where there are 2 other dead bodies. She can't get out, and the person who's doing this to her is sleeping. So she's trying to quietly call 911. She doesn't know exactly where she is. She's trying to give general descriptions. They ask her what color the house is. She tries to explain that. But this is all trying to get information to save her life while the perpetrator is sleeping right there. So the fear that she must have felt making that call, it's hard to imagine how that actually feels, because we've never experienced anything like that. But you could hear it in her voice. And fortunately, how many lives did that save? Because other victims might have been saved because he was been brought to justice. But in terms of this case is all about whether the defense can save his life from the death penalty, right? The evidence is overwhelming. You have this victim's testimony identifying him. You have all the evidence in his home. You have 2 dead bodies who are decomposing in his home. So this isn't a case of what he really did or who did it. It's a case of should he get the death penalty for it? And that goes into that strategy of pleading guilty to some charges, trying to get some sympathy from the jury, maybe for the death penalty phase.
Well, you know, we're going to talk about that, I guess, until we actually listen to the participants in the case, because I find it odd personally, and I have never been involved in a homicide case where I have seen somebody open up to a jury, say that they're not guilty of these things, and wait till you hear all the evidence come out, so on and so forth, and then actually plead guilty to a number of offenses in the middle of the case. I'm not certain that it was a great tactical move. I'm not sure that this is the kind of individual that can garner any level of sympathy with the jury. These are disgusting, horrific acts. They're torturous. He throws them away like trash. They're rotting when the police find them. It's about as bad a case as you can get. So I don't think that the defense, I get it, maybe they're going to say, well, he accepted responsibility, but that jury came back with capital murder offenses across the board real fast. So let's talk a little bit about mitigating and aggravating factors, and what do you think? I hate to do this to you, because I hate to do it to myself. I hate to do it, it as a homicide prosecutor, but flip the script a little bit. You're the defense lawyer. What are you saying here, Dan?
Sure. Well, just before I get to that, I just want to say it's not just the sympathy of pleading guilty. It's the fact that the prosecution wouldn't enter all the evidence they had if he pled guilty to those charges. The defendants had supposedly recorded some of the sexual assaults that the prosecution could have played for the jury. And by pleading guilty to these charges, the prosecution didn't have to do that or couldn't do that. So maybe that stopped it from being even more horrendous. But to get to your question...
Well, wait a minute. Now I got to interrupt you.
Sure.
So we're going to have to reverse this question. We're going to have to have this, the first question last and go to what you just said, because I think it's a really important point for our viewers and our listeners to know. I'm not sure about the tactics of the defense, but I got to tell you, I like the tactics of the prosecution. I talked about this yesterday, and you know this as well. It's not, I used to say this all the time to my staff, to the lawyers. It's not just about winning a conviction. It's about winning and surviving appeal, especially in a death penalty case where the highest level of scrutiny is given. We don't know all the facts, but from what we're reading right now, we believe the prosecution made the tactical decision after he pled guilty to those other offenses to say, you know what, I'm not going to introduce this compelling video evidence of the crimes themselves being committed. And I think that that was a brilliant move, because down the road, the appellate division is likely to review this case and say, you know what, this prosecutor was judicious. The prosecutor was doing it tailored just based upon what they needed to prove and not prove. They didn't do overkill, which happens many times with prosecutors. They go too far, and then they have to wind up trying the case again. So what do you think about that in terms of a tactic for the
definitely.
prosecutor?
Smart move by the prosecution, but the defendant pleading guilty to those charges made it an easier decision for the prosecution not to bring in that evidence, because it wasn't really necessary. It might have, like you said, created an issue for appeal. If the defendant hadn't pled guilty to anything, maybe they would have been more pressed to enter it, although there's a lot of reasons not to play those tapes. It's not necessary because the evidence is overwhelming here. And also, you're showing people, the victims, being sexually assaulted, because that's what was recorded on camera. And that's upsetting for a lot of reasons. It violates the privacy of the victims to have that displayed in court, whether they're alive or dead now, to show that in public, which court is public, actually being sexually assaulted. So it was a smart move by the prosecution. I agree with you.
Okay, well, listen, it'll be interesting to see whether or not there's going to be an attempt to introduce that evidence in the penalty phase, because the penalty phase is much different than the guilt phase.
Absolutely.
So stay tuned, guys, for that. For our XM listeners, it's great to have you on board for Sirius. And for our law and crime faithful who are always bringing those questions in, we're going to have an opportunity to go back to the Gault trial. We're going to play a little bit of the closing statements for you. Come on the other end of that. If you have any questions, please put it out there, and we'd love to answer them. So let's go back and look at some of this closing statements in the Gault case. Hi, I'm Bob Bianchi for Law and Crime Network, hosting today with Dan Schorr, and we have just been listening to the prosecution's closing statements in this horrific case with this 18-year-old man on trial for killing his 16-year-old ex-girlfriend. But, I mean, we got lots going on here, including a cop defendant on trial for having fatally shot a motorist who was broken down. He is now the cop standing trial for having killed him, and he's arguing that he should be entitled to the stand your ground law. It's a fascinating factual case, but we're going to talk about that a little bit more when we get back on the other end of this commercial break, so stay tuned. Hi, Bob Bianchi for the Law and Crime Network. Welcome to our faithful followers online, as well to our Sirius XM listeners. Great to have you guys. Keep the questions coming. When we get to the next break, I'm going to try to real quick go through them when I have some opportunity. We got so much going on now. Now, this Ranga case, we're going to talk about this a little bit with Dan, and I'd also like to bring in an attorney from West Palm Beach, Florida, Richard Tendler, who often comes on Law and Crime Network. How you doing, Richard?
Great, doing great here, Bob.
Yeah, listen, man, I think that this case, this police officer who is charged with having unlawfully killed a motorist who was actually a band player. His car had broken down. He was not doing any criminality. He was doing nothing wrong. He's a guy who was in the wrong place at the wrong time, and this officer is alleged to have unlawfully shot and killed him, and the facts in this case are fascinating. Give me your initial impressions of what you see are going to be the issues, especially as it relates, Richard, to the stand your ground law in Florida.
Well, here it is in a nutshell. We're getting to see really a mini trial of what's going to happen at the actual jury trial, because I expect that this motion is going to be denied. So we're getting a preview of it. Now, in Florida, we have what is called a stand your ground law. And so essentially, the prosecutor has the burden of proof to show by clear and convincing evidence that the defendant did not commit this crime, that the defendant wasn't entitled to the stand your ground defense. So all the burden is on the prosecutor. Now, essentially, what we have here is the defendant having approached this individual. What ended up happening, and I can give you the facts of it. I don't know how detailed you want me to get into it.
I don't want to get into the facts right now. I want to explain to the viewers and our listeners on SiriusXM a little bit more about the stand your ground law, because it's so crucially important before we even get to the facts. Richard, let me ask you a question about Florida law. I'll tell you how this rolls in New Jersey, even though we don't have stand your ground. So to make it very clear, stand your ground simply means that you don't have to retreat when you are in a scenario where your life is in danger. Whereas other states like New Jersey, and I will talk to Dan about whether New York is the same way, is that if you have a reasonable ability to be able to retreat without harm, you must avail yourself of that before you can argue self-defense. So is that law basically the no retreat law, saying basically you don't have to retreat? Is that what's at play here, Richard?
It is, and it goes a step further in Florida. Some people call it the Wild Wild West down here.
Okay.
You don't have to be at home. You basically, you can be anywhere. You can be in your car. You can be out in public at a restaurant. You have no duty to retreat whatsoever. And then not only do you not have a duty to retreat, but if you use self-defense, the prosecutors have the burden of showing that you weren't entitled to use self-defense.
Well, Richard, that's exactly where I want to stop you, because I think that is the key to what is happening here tactically by the defense. And let me see if it's the same in Florida as it is in other states. In other words, what you were saying, and so our viewers and our listeners on SiriusXM understand, this is some really heady law, but this law is really important to understand this case. And that is when a defense is offered, what they call an affirmative defense in the criminal code, self-defense being one of them. If the defense is allowed to bring that defense forward, which is what's being argued right now at this hearing, at least in New Jersey, and I'm clear, I want to hear what the burden of proof is in Florida, but it switches the burden at that point in time. And the prosecution not only has to prove its case, it has to prove beyond a reasonable doubt that the defense is not applicable. Is that the same in Florida?
Slightly different. They've got to prove by clear and convincing evidence on this motion that the defendant wasn't entitled to use self-defense.
Right, that's for this motion. But if this motion is denied, which we believe is likely, in other words, their prosecution is going to be able to move forward. But if the judge allows this defense to go in at trial when that evidence is introduced, does not the prosecution have to disprove self-defense beyond a reasonable doubt? Doesn't the burden get higher at trial?
Absolutely.
Yeah.
Absolutely.
So listen.
And so they'll have that burden. Absolutely.
Yeah.
And they'll have to prove that and the case beyond a reasonable doubt.
Right, so this is a big thing, because as a prosecutor, as a homicide prosecutor, you got a double whammy with something like this. You got to prove every element of the offense beyond a reasonable doubt. Then you have to disprove beyond a reasonable doubt the affirmative defense. Dan Schorr, what does this look like in a courtroom for a prosecutor, and does this not make the prosecution's job more difficult if you've got that self-defense no retreat law in Florida?
It could make it more difficult, but I think that the stand your ground law is often misunderstood, because even in the stand your ground cases, you still have to have an imminent threat of deadly force against you. So it's not, I think people think of stand your ground colloquially as you could just shoot someone if you want to, if there's some kind of argument, and really there has to be an imminent threat that's reasonable that you perceive of deadly force. So here, if he's saying, the defendant, that he thought he was going to be shot, it's hard to see how he would have retreated if he could have, rather than fired the fatal shot. So it really comes down to credibility and his reasonableness. Is there a reasonable imminent threat? And because of some of his inconsistent statements and the recording that might have contradicted some of his accounts, then that makes it it's tough for him to win on this hearing, I believe.
Yeah, Dan Schorr brings out a great point that before you even get to this retreat, no retreat, the bottom line is you have to have been facing an imminent risk of serious bodily injury and or death. Otherwise, self-defense does not apply. So now we know the parameters of that very complex law. My guests, Richard and Dan, did an awesome job at explaining it. Now it comes down to what all cases ultimately come down to: facts, facts, facts. What facts are going to be there in support of one side or the other? Richard, what are you seeing out there in terms of the basic prosecution case as to why they chose to go against, if you will, one of their own, a police officer, and file charges here against him? What are the facts most compelling for the prosecution?
Here's what's really going to hurt the defendant. Everything that led up to this, the defendant approached the victim in this case, had no police insignia on him whatsoever, approached in a very aggressive manner, so that Corey Jones, the victim, who was fatally shot by the defendant, had no idea that it was a police officer there. And then, to make matters worse for the defendant, Corey Jones, the victim in the case, had been on the phone with AT&T roadside assistance. And that call captured the entire events that went down from the time that the police officer approached him to the time that the shots were fired. While about 30 seconds after all the shots had been fired, the defendant calls 911 and makes it out as if he had just fired the shots, when meanwhile it was done 30 seconds prior, and he makes it out like this is still actively going on, when in fact he had no way to know that he was being recorded on that AT&T roadside call. That is very damning, very heavy evidence against him.
Yeah, hey, Richard, great factual rundown, and there's so many other pieces to this. And listen, I'm a prosecutor by nature, okay? I've done that for most of my career. I led prosecutors. I supervised 44 police agencies. I'm a cop supporter. But I got to be honest with you, Richard, Dan, I mean, I am seeing some use of force cases that are going out there and some shootings that are being captured on video, 911 calls, so on and so forth. Really disconcerting. You know, I know some great cops tactically who understand the idea that even if you can doesn't mean you should. But we're not dealing with that kind of case here. Dan, we're dealing with a guy who was broken down on the side of the road, if you will, calling his friends, calling for help. As Richard indicated, he's on the phone as this cop comes in this very aggressive manner. And Richard, to point out also, he was on this tactical detail, this police officer defendant, where they were looking at car burglaries going on. He doesn't identify himself as a police officer. Contrary to his training and the supervisor's requirements that he have his safety vest on, no markings on the car, no badge hanging from it. I mean, obviously the victim in this case, in this desolate area broken down, is going to be more afraid of the guy who turns out to be the cop than the other way around. What are your thoughts, Dan?
Well, look, in a lot of these excessive use of force cases, there's a question of, did the person who was shot or who was injured by the police officer, did that person do something wrong that led to the situation? Here, there's clearly nothing wrong by this victim. He was broken down. He tried to get help. There's no evidence he showed a weapon or did anything improper. There's no evidence he knew the person was a police officer or that he started a confrontation. So he should not have been shot. He should not have been killed. He should be living with us today. Now, the question is, did this defendant have a reasonable belief? Might have been a wrong belief, but was it a reasonable belief that there was an imminent threat to his life or to his safety?
And to that point, I think, Richard, you brought out very clearly the tape is very compelling in terms of the over-officious nature of which this man was approached. The fact of the matter is 3 shots were fired when that gun had been dropped after the initial first 3 rounds had been fired some 40 or I believe or 50 yards away. And then the cover-up. And I got to give the police department credit. When you look at their initial investigation report, they knew something was squirrely. They weren't going into cover-up mode. They were ready to do their job and to properly assess the facts of this case. Trial is fascinating. Hey, listen, folks, the Law and Crime Network, for our Sirius XM viewers or listeners, we love having you on board. We're going to go quick to a commercial break. And after, on the other end of that, we've got all this going on, the Gault trial, the Grate trial, and then we got this great case with this police officer, which I really love. You got to love the Law and Crime Network. And now we're going to go to break. We'll be back on the other end of the show, of the break. Thank you. Well, welcome back to the Law and Crime Network and to our Sirius XM listeners. Great to have you on board. So we are going back to the William Riley Gaul case. This is the case where an 18-year-old man is on trial for killing his ex-16-year-old girlfriend. And we have with us Dan Schorr, who has got a tremendous amount of experience, not only investigations in a private investigative company he works with, but also as a former district attorney in 2 district attorney's offices in New York, having done special victims cases as well as homicide cases. And the fascinating part, we were talking about this, Dan, before we go through one of the prosecution clips here. And Richard, I guess you're still with us here. I don't know if you've been following and watching the case. Welcome back. Is that there is going to be a significant dispute here, and there is already, about whether this is murder or manslaughter. My view on this, Richard, I already talked to Dan about it, is that you got that ace in the hole for the prosecution, felony murder. What are your thoughts?
Well, that can cut both ways. I mean, it's a legal argument, and jurors are not always keen on legal arguments. They're great in front of a judge, they're great in front of a certain set of jurors, and sometimes jurors can get offended by the whole thing. But then again, prosecutors love to throw it in, because it makes it that much easier to prove their case. And, all of a sudden now, as a defense attorney, you kind of hate it because it's like, they get you on the hook for that one. So, as a defense attorney, you're hoping that one of these jurors gets offended by it.
Well, Richard Tendler, you just explained the reason why I loved it as a prosecutor and why you hate it as a defense lawyer, because it is the safety net, the catch-all, that if that worst-case scenario, you got that beautiful, huge, expansive felony murder charge. I understand that there's a lot to it where people don't like it, but nevertheless, it is a great prosecutor's tool. But let's be honest, I said this yesterday, Dan, I am not popping the champagne or having some Coors Lights with my friends unless and only unless I get a murder conviction. I don't want just felony murder here. I want to know, as a prosecutor, I actually proved that this was an intentional act. I mean, that's what the prosecution is going for. That's what they consider the win. What are your thoughts, Dan?
Well, I think it comes down to sentencing, because if you're going to get him put away for the same amount of time, then you might be okay with felony murder. But I know what you mean. This defendant, there's a lot of evidence that he intended to shoot this victim and kill her. And from a prosecutor's perspective and for justice, you want to be able to prove that. So he is proven guilty to actually intending to shoot this victim here who he was stalking and had all this other bizarre behavior with. So in that respect, you want the intentional murder conviction, but ultimately for the defendant, it's going to come down to sentencing. If felony murder puts him away for just as long or almost as long, it's not much of a win for him.
Yeah, much more satisfying to actually win all the charges as a prosecutor, of course. But Richard, I'd like to go to you and ask you, I got to be honest, I think that, and I'm watching our friends on the Law and Crime Network blog, and there are a couple who are kind of like, I'm not sure I'm really convinced that this was an intentional or purposeful murder as opposed to a reckless act. And, when you're shooting 2 rounds, I get the prosecutor's argument. They did the best that they could with that. I mean, this is something. Do you believe that maybe one juror could maybe say, I'm just not convinced that this is what he was intending to do? And I'm going to add to that, what importance was there, we're going to throw to a clip after you answer this, to the prosecutor trying to bloody up, for lack of a better expression, the defendant about all that previous conduct that he was doing in order to try to prove that this was intentional? What are your thoughts, Richard?
Well, you're exactly right, Bob. Prosecutors love going into everything that happened previously. They love it. I mean, it's never good for the defendant. It just isn't. And in this case, no doubt. If these attorneys can get the jurors to concentrate just simply on what they've told them and what they put through, what they put forward, and that specific act, perhaps you get 1 or 2 on there that think, you know what, I'm not really buying it 100%. Prosecutors got the burden, and I'm just not convinced. And maybe they start swinging a couple of them back there, and you get some type of compromised verdict. I don't know.
Yeah,
but that's the hope.
Yeah, I think that you basically hit the defense theory of the case right on all fours there, Richard. So let's go to the part of the prosecution's closing statement, whereas you just indicated, Richard, they're trying to bloody him up with some of this previous information in order to prove that this action wasn't just reckless but intentional. Let's go to the prosecutor's closing statement. And thank you for you guys on Law and Crime Network. Keep those questions coming. And for Sirius XM listeners, listen to this prosecution closing here and listen to what they're doing about the previous conduct prior to the actual death itself.
Find it.
Well, welcome back to the Law and Crime Network and to our Sirius XM listeners, which we love having you on. I love watching these comments, by the way, on the Law and Crime Network website. And we have Dan Schorr with us, who's been going on with this case, and Richard Tendler from West Palm Beach, Florida. Guys, I got to talk to you about what I thought the prosecution did here to knock it out of the park in terms of their side of the case. I love the idea. I personally, we've talked about this already. I personally have not seen these cases where people are pleading guilty in the middle of a trial. And not only was it good, I loved what the prosecutor did with it. He basically said by him pleading guilty, he just basically proved, Richard, I know you're not going to like this. I know you may get a little look on your face, but he essentially locked down felony murder for the prosecution when he pled guilty. And the prosecutor very deftly must have mentioned that, I don't know if you guys counting, 99.76 times. I'm being facetious here, but he kept going back to the idea. Here's what he said. Once he pled guilty during the trial, well, we know that he's the guy who did it. It's not a whodunit any longer. We know that he's the one who fired into the room. We knew that he now knows that the girlfriend was in the room, and that we know that she was a child by definition under the law. And also that we also know that therefore is the predicate felony. He was spelling it out chapter and verse. That's the predicate felony. And he essentially was saying, guys, hey, listen, this one's a no-brainer here. But also there's all these more serious charges. That's the prosecutor covering his bets because that felony murder charge is huge. Before I toss to you guys, I just want to bring up something that I love that he did right after that, bloodying him up with the cover-up. Jurors don't like cover-ups, the matter-of-factness of this cover-up, and then going through all of his deceptions. I personally thought as a craftsman, as a trial lawyer, the prosecutor really brought all of those elements very well together. Dan, I'm curious, before we go to Richard, what were your thoughts on how he tied that together with felony murder?
It was really strong. The felony murder seems very, very strong, as does intentional murder. I mean, there's just overwhelming evidence here. The cover-up is interesting because usually that shows consciousness of guilt, but consciousness of guilt here could be consistent with the lesser charges that he pled guilty to also. Let's say, as the defense said, he was just trying to create an incident to get sympathy, to get her attention, and then she ended up dying. He might also want to get rid of the weapon and try to get his friends to help him. So that is consistent with the defense theory also. But the defense theory is conceding a lot of points and maybe has conceded the felony murder elements, as you just said.
Yeah, Dan, listen, I think as we get to Richard, this point cannot be underscored enough. I'm sorry if I'm saying it as many times as the prosecutor did in the summation. The centerpiece of the prosecutor's case is felony murder, felony murder, felony murder. He did a great job at that. They want the intentional, but the prosecutor knows. They have to know. I would know as a prosecutor, very consistent with what you said. The deceptions, the cover-up, that could be just to cover up the fact that I did something recklessly that caused somebody to die. While it's good evidence to prove that he's the person who did it, it's not necessarily going to make the day as to a purposeful or intentional or premeditated murder. Richard, what do you think about that?
Here's the thing. It's incredible what you'll find when a defense attorney gets up in front of jurors and says, yeah, find him guilty of what we told you he's guilty of. Jurors are amazed by that. They think, oh my God, we got a defense attorney who's not trying to get one over on us. We got a guy who is being upfront with us. And so let's hear what he has to say or what she has to say. And so essentially, they're going to say he's admitted to what he's admitted to. He's admitted to what he did. He didn't admit to anything more than that. And therefore, don't find him guilty of what this prosecutor wants you to go down, because this prosecutor has nothing else, or he wouldn't be spending all this time talking about some other crime.
Well, I'm going to talk about the most important thing for our Law and Crimes viewers and our Sirius XM listeners, and it's called the host privilege. And the host privilege is Richard. I respect that opinion, but no one is going to ever convince me, as a guy who's been doing this for 30 years and trying homicide cases, that is a good idea to, in the middle of the trial, plead guilty. Why didn't the defense attorney plead guilty before it went to the jury? I just think it's a tactically wobbly, strange thing to do. I respect your opinion. Apparently, the defense attorneys agreed with you in doing it. There must have been a tactical reason to do it. So thank you for that opinion. I certainly wouldn't, as a defense lawyer myself, ever go in front of a jury in an opening statement and say, wait till the prosecution proves its case, and then in the middle of it plead guilty. I don't know how the jury's going to interpret it, and that's not a place I want to be. But listen, we're going to come back on the other end of the break and talk about all these fascinating cases on the Law and Crime Network with our great bloggers that are out here, and appreciate all the commentary that you're making, as well as our Sirius XM listeners. Love having you guys on board with regard to these fascinating trials. And we're going to go toss to a commercial break, and we'll come back on the other side of that break. Thank you. Okay, we're back at the Law and Crime Network and welcoming our Sirius XM listeners to the William Riley Gault trial. This is a case where an 18-year-old man is accused of having killed his 16-year-old ex-girlfriend by firing 2 rounds inside of her bedroom window, one of which struck her in the head and killed her. The big dispute here, was this an intentional act or was this just a reckless act? And what's the difference? It's the difference between a life without parole sentence on a murder charge versus a reckless manslaughter charge would have a significantly reduced sentence. We've been doing a lot of discussion with Dan Schorr and Richard Tendler, my great guests that we've had here, about felony murder and what this all means tactically. Guys, we are really in the flesh of what real trial lawyers are thinking about when they're in that courtroom in terms of winning cases and not winning cases. Richard brought up the point that it may be beneficial to the defense to have pled guilty. This is what occurred here in the middle of this case. He actually pled guilty to, during the trial, having shot the rounds inside of the bedroom. But what's at issue here is whether or not it was a premeditated, intentional act or not. Richard thinks and suggests that it's possible that this may boost or bolster the credibility of the defense to say that they're willing to admit responsibility. It certainly is a valid argument to make, certainly not one that I would do or have ever seen. But we'll see how it plays out. They tactically know better than we do. But to Richard's point, to Dan, who's done a great job with the analysis in this case so far, it is only fair, Dan and Richard, that we must look at, unfortunately, and I'm only kidding when I say that, let's look at the defense closing here and see how they were positioning this case. Okay, we have been listening to the closing statement of the defense attorney in this case, in the William Riley Gault case. This is the case where the 18-year-old man is accused of having shot his 16-year-old ex-girlfriend from outside. He shot into her window, 1 bullet striking her head and killing her. We've been discussing this with Dan Schorr and Richard Tendler, our experts have been doing a phenomenal job in evaluating this. Something that struck me with regard to the defense thing, it's something that we've all heard from law school and trying cases. When you have the facts, argue the facts. If you have the law, argue the law. We have neither. Bang the table. What I see this defense lawyer doing here is he's doing a really good job at just flooding the jury with law about intentional acts, premeditated acts, and kind of lacing in there the fact that this was just a wayward teenager. He must have used teenager Richard as many times as the prosecutor used felony murder, those phrases. And so that you guys know this is what it's really all about. And I think that he's done an adequate job in this case because the law is complex, it is confusing. Jurors oftentimes are confused by it. So what do you guys think about the approach the defense is taking? Richard, I'll start with you.
You know, you're right, Bob, in that I don't know if I would have, just pled guilty. I would have let the jurors. He could have done the same thing with his intent on wanting to plead guilty and tell the jurors that he was guilty of that, and not pled guilty and let the jurors make that decision on their own, and told them, hey, go ahead and click and check off guilty in that area, under that count. However, he didn't do it that way. But now what he's doing is exactly what you said, Bob. He's telling the jurors as much as possible that this is a teenager. Teenagers make mistakes. Teenagers are dumb. He has said that from the start of the trial, that you're going to see weird conduct. You're going to see conduct that is unexplainable, and that is part of just being a teenager. So, yeah, he's done a very good job of trying to weave that in together. He's also taken the reckless conduct and the reckless language that was in what he pled, and he's trying to tie that into some of the reckless stuff that of the language that is in the homicide portion and the murder portion of the statute, and he's going to try and decipher that. That makes any sense.
Listen, we're going to take a quick break, and on the other end of that, we're going to come back and ask Dan his astute opinions about how the defense did. Richard, great analysis, so thank you. For all of our law and crime loyalists that are on the website, keep those blogs coming. I love watching the commentary. And for our Sirius XM listeners, love having you on board with these fascinating trials and with these two awesome guests. And we'll come back to you on the other side of the break. Well, welcome back to Law and Crime Network. Nothing like a good fight in a courtroom that we just saw there on that preview for our Sirius XM viewers. Unfortunately, you'll have to catch that on the Law and Crime Network website. It does get hot in a courtroom, a lot of emotions. I've always said it's the arena of the best and the worst that human nature has to offer. That's why I always love doing criminal law trial work. It's really an entertaining field. No two cases ever the same. So I want to thank our guests, Richard Tendler and Dan Schorr, here with us. We were talking about the trial of the 18-year-old man accused, William Riley Gaul, of killing his 16-year-old ex-girlfriend. And Richard just gave us an analysis of the defense closing statement, which I think was a very poignant one. Dan, what do you think about it? Do you think it was effective?
I think it was the best they could do with the facts that they have. He made a lot of discussion about him being 18 years old, and he played it off as if he's young and foolish. And I understand he has to do that. But when you look at it objectively, this is someone who's 18 years old. So he's not a 14-year-old. He's not a 15-year-old. And just from the facts that the ballistics show and that he admitted to, there was repeated stalking behavior. He stole a loaded gun. He went up to the victim's home and from close range fired 2 shots into the wall right where he knew that she slept, because he had been there and he knew exactly where she slept. So this is very conscious, deliberate behavior from someone 18. You've reached a certain age of maturity at that point. So to play it off as he's some reckless kid, I don't think is accurate. But of course, the defense has to try that.
Okay, listen, great analysis, guys. You cannot believe this, Law and Crime Network fans, Sirius XM listeners. We have yet another trial that we have to go to. You got to love this character. We're going to go into the courtroom in a minute, but his name is Jeffrey Willis. I put my glasses on and I'm going to look down on this piece of paper because it is that creepy, weird, twisted kind of case that we love breaking down here, although it's kind of frightening living in a world like this. This is a case where a 2013 woman in Michigan was disappeared and is now he's on trial for that. But that's not all. He was found guilty in 2014 for having killed another person and is ready for another upcoming trial for the kidnapping of a teenage girl that escaped yet again from a van. So, I mean, this is going to be an amazing case. The guy is not your best guy, that's for sure. But you know what? He actually taunts people inside the courtroom, blowing kisses. I mean, as a prosecutor, again, it's a prosecutor's dream to prosecute a guy like this. Let's go into the courtroom and see what's going on in this, what will be an absolutely fascinating case, State versus Jeffrey Willis. Okay, just a short interruption, Law and Crime Network here, and welcome to our Sirius XM listeners. We are dealing with the hero, Jeffrey Willis, and I am saying that with great facetiousness on my face for you Sirius XM listeners. This character is something else. Horrible, riveting 911 call, really bringing home to the jury the emotional impact. Sometimes it can be a little antiseptic in that courtroom. Great play by the prosecutor to start the case off with this. But unfortunately, I'm going to have to say goodbye to Dan. He has done a tremendous job. I I love being on with a pro like this because we can really talk about the backgrounds and tactics. Dan, thank you. Richard's going to stay here with us, I believe, a little while longer as we go back to the courtroom, but I want to thank you so much for your expertise and being on the show.
Oh, thanks. It's great to talk with you, both of you. It's been a really interesting conversation, and there's so many interesting cases that are going to continue to be watched here, so I'll definitely stay tuned in.
Okay, great. Richard, you hang in there, and let's go back to the courtroom and watch this testimony. Okay, welcome back to Law and Crime Network and to our Sirius XM listeners. Bob Bianchi here hosting with Richard Tendler still from down there in Florida, and we're listening to the Jeffrey Willis case. And I just want to give some basic facts, and then I'm going to toss over to Richard if we have some time while we have a little bit of a downtime in court. So this is the 2013 disappearance of Jessica Ranga. It wasn't solved until years later. It's a murder abduction case. She was working at a gas station when she was abducted. Actually, later on, after solving the case, they found blood of Mr. Willis at that location. The woman, the girl, the teenage girl who you heard on the 911 tape that was abducted was the puzzle piece that was needed for them to solve that. In another case, he had been convicted of murder last year. He's got another case pending that's coming up. He's got this case. This guy's got it all. So I know we got some testimony, but I just want to give you a little bit about the victim, because you know what? As prosecutors, we feel there's not enough about the victim in a case. It's always about the defendant. So Jessica Ranga was a single mom of a 3-year-old child, 25 years old. The date of the incident was on April 26, 2013, when she was abducted. And we're also going, there were thousands of tips. It was unsolved for years. And a little teaser here, one of the witnesses that may testify in this case is his cousin, Kevin Blum, I believe is the name, the way that you pronounce it, who helped discard the body after the crime was committed. That could be a very crucial witness. So let's go back into court and listen to the detective, the lead detective, Matt Schultz, in this case. Well, welcome back to the Law and Crime Network. We're watching the lead detective testify in the case, and I wanted to interrupt real quick to thank my guest, Richard Tendler from West Palm Beach area, Florida, for his great commentary. And unfortunately, Richard, I know guys like me and you, I love this stuff. I could stay at the Law and Crime Network, give me an IV, and talk about crime 24/7, but alas, I must go. The great Lise Wheel and Linda Kenny Bodden is going to be the next group of people. Awesome host and guest. And thank you very much for all of your comments. Richard, thank you for your commentary, and hopefully we'll be seeing you shortly. Enjoy the rest of this trial.
Absolutely. Great meeting you, Bob.